What happened to your eye?
I got sucker punched by someone coming off drugs.
Okay. Do you need me to call over to the jail about that?
No,
I regret that you won't be able to participate. I think you were prepared to
I was.
change your life.
I was.
All right. Well, once you're released,
Change that.
that's good. Once you're released, if you can't find a place for treatment or something of that nature, if I'm still here, you can come by. I'll call and see where we can place you. Okay. Court is calling 2024 CR 008840 State of Texas versus Christopher Andrade. Can our parties announce for the record for the state?
Jason Garahan, Your Honor.
Defense.
Lorraine Ephraim for Mr. Andrade.
And are you Mr. Andrade?
Yes, ma'am.
What happened to your eye?
I got sucker punched by someone coming off drugs.
Okay. Do you need me to call over to the jail about that?
No,
Okay. All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Christopher Andrade who was placed on community supervision in 2024 CR 008840 for the offense of evading arrest detention with a vehicle on September 27th, 2024 for a term of 8 years? Is that you? And counsel, do you waive notice?
Yes.
All right. State, you may proceed.
Thank you, Judge. Violated condition number 39 on or about the 10th day of December 2024 in Bexar County, Texas. The defendant Christopher Andrade did then and there failed to comply with the rules and regulation of ethical on report, and that they no longer wish to participate in violation of this condition.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of condition number 39, the court could find it true, grant the motion, and sentence you up to 6 years in the prison and up to not a fine, but just 6 years in prison. Did you understand that?
6.
No, that's what I could sentence you up to. All right. Did you understand that? Knowing that, do you still wish to plead true to violation of condition number 39? All right. The court will find violation of condition number 39 true. And just so you're aware, the court is aware, based upon conversations with the state and the defense, that your reason for not wanting to participate is not really because you didn't want to participate. It's because you've been sentenced on another case, and regretfully, they didn't continue. If they would continue you, of course, we would have worked with you to make sure that you successfully completed this. So I'm aware of that. So knowing that, is there an agreement?
There is, Your Honor.
And what is the agreement?
It is revocation, Your Honor, and reform the underlying sentence to 2 years, and to run concurrent. I don't have the number, but concurrent with the triple parole.
I have the number.
All right. And the agreement that they worked out, are you asking the court to follow that agreement? Are you waiving the right to appeal? All right. So then the court is going to grant the motion. The court will revoke. The court will sentence you to 2 years in the prison, give you credit for any time served, and this will run concurrent with your parole case number.
And I cannot find the actual case number on these documents.
All right. If you're able to find that cause number, just let the clerks know and we'll put it in, they'll put it in the system.
Okay. Do you happen to know?
And I'll see if I can look it up as well.
Okay.
All right.
Yeah.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right. And I'll put in the therapeutic community. It doesn't increase the time that you're in custody, but if you want to take advantage of it, and if they give it to you, they'll know that I'm recommending it. All right, we can go off the record. I regret that you won't be able to participate. I think you were prepared to change your life.
I was.
All right. Well, once you're released,
Change that.
that's good. Once you're released, if you can't find a place for treatment or something of that nature, if I'm still here, you can come by. I'll call and see where we can place you. Okay.
Thank you.
All right. Good luck to you. Yes.
On your
Yes.
It's not the same person.
Ah, okay, all right. Over the indictment with you, and they say there's not an issue with the indictment,
I understand.
then they're not gonna file any motions.
Well,
as it
he
relates to
hasn't
the
gone over the indictment with me. And
All
that,
right, sit over in the box. He'll go over the indictment with you. All right,
so I can't, I don't have no confidence in.
all right. So
him.
what you can do is you can sit in the box with your attorney. Your attorney will go over the indictment with you.
Okay.
Thank you.
Judge, there's also the mental health issue that that I mentioned earlier. I've learned that he's not taking his medication, he's hearing voice.
Okay,
And so I'd like to file a motion for mental health eval.
all right. Who's the prosecutor on Ricardo Garcia? Defense counsel is requesting a competency evaluation. So,
Sorry to interrupt you. I conferred with defense counsel earlier and I have no objection to his motion.
all right, so he's gonna go back. The court is legally bound to give a competency evaluation when it's requested. So recall this back and we'll put it for jury trial. We'll put it for January 27th and see if the competency evaluation is completed. If it is, that's the date for your jury trial date.
Thank you, Judge.
All right, thank you.
May I be excused?
You want to tell your client?
Yes, Judge, I would.
Sorry.
Right.
Sure.
I just want to say for the record, I understood what you just told me, and we had the opportunity to go over the indictment when I last came to court, when I found out I was indicted,
Mhm.
and I was ushered out, and he explained to me that he was gonna come visit me. I've been incarcerated for 10 months already, and I have not had one visit from this man or had any written correspondence from him. He's given me two different numbers that I haven't been able to get a hold of. He told me he was gonna be out of town the last time that we talked for the holidays. So that's the reason why I figured he didn't answer the phone now. You asked him to go down and sit down with me over this indictment,
Mhm.
and he pulled up that mental health issue without coming to me and asking me, hey, you know what, I'm gonna ask for this motion to go in. Motion that I would have wanted to him to put in, we haven't discussed or gone over this indictment, and I've been indicted since August 15th. I wasn't known, this wasn't brought up to me till October. And he still hasn't gone over this indictment with me or discovery, so,
All right, so here's the
Okay.
thing. I'm going to take this process with you step by step.
okay.
If there's something that I tell you that you don't understand, just let me know. Okay? So this is based upon my experience
Yes, ma'am.
as a defense attorney.
Okay,
Sometimes as a defense attorney, you don't know when your client has been indicted. And let me just tell you why. The reason why you don't know is because you're not his only client.
Yeah.
Sometimes you have attorneys who have 12 and 15 clients, sometimes more. So they don't go on your case and they don't look up every single day to see if you're been indicted.
Okay.
So sometimes what ends up happening is how they know you've been indicted is they receive a letter in the mail or card in the mail saying this case is set for today,
okay,
which means that the case has been indicted.
okay,
The prosecutor, they don't pick up the phone and call
Yeah.
your attorney and say, hey, just so you know, I'm taking your client's case to the grand jury tomorrow.
okay,
And then if the grand jury says, yes, there's enough evidence to hold them over for trial and we're going to indict it, the prosecutor normally doesn't pick up the phone and call every attorney that's on that list and say, hey, just to let you know, the grand jury indicted your client today. So sometimes the first time that a defense attorney will know, and this is not saying anything bad about the defense attorney, this is just the way it works. Sometimes they don't know that you've been indicted until they get a notice telling them they need to be in court because your court is set that day. And let me just tell you, with indicted cases, I won't know you've been indicted until it gets set on the docket.
Okay.
And I don't set it on the docket. It's done automatically through the computer system. So that's why he can't come to you and say, oh, by the way, you've been indicted. He knows you've been indicted when he's ordered to be in court. So he's here today, right? Now, the next step in the process in this court, I make sure everybody has all their discovery, and then I require the state to tender an offer. Once the state tenders an offer, then your attorney will let you know what the offer is. You can either accept it or reject it. I'm here all day. So if you don't want to accept it, that is fine. Then you'll be scheduled for a jury trial. So today is your jury trial date. Now, what holds up a jury trial? Sometimes maybe there's some new discovery that's been given. I don't have the defense attorney's requests continuances normally for that because it's not really their fault.
No.
Now, if your attorney thinks that there are some mental health issues, what do I mean by mental health issues? They feel as though you don't understand what you're charged with, the consequences of the decisions you're making related to that charge, or if they see that maybe at the jail it says that you've been on mental health medication, they may say, maybe this person isn't competent. And once an attorney legally comes to the court and says, I believe this person needs to be evaluated to see if they're competent to stand trial, then that stops everything. And then what I have to do legally is I have to send notices out, send an order out saying, I want this person evaluated for competency, because it wouldn't be fair for an attorney to go to trial with the client and that client doesn't know the consequences of the decision he's making. And as someone who's accused of a crime, you have certain rights. You can make a decision on whether you want to testify or not. That's not your attorney's decision. Your attorney may advise you, but that's your decision. You can make a decision on whether you want to enter into a plea agreement or not. You can make a decision on whether or not you want to waive jury trial, but the waiver of the jury trial, the state has to agree to it as well. So your attorney has stated to the court that he believes there may be some competency issues here. So with that being said, legally, I must, and I will, have a doctor come see you to evaluate you. And then we're going to come back, and we're coming back on January 27th, because that's the length of time it's taking to get evaluations done. I don't know if your evaluation will be completed by that time or not, but we will see.
Okay, I partially understand everything that you explained to me.
what
I
do you
want to
not
say
understand?
thank you.
Let me know.
What I don't understand is if I have certain rights, the way you expressed, and his obligation to go over those indictments with me when he gets notice of it. Okay, so this is the second time that I've seen him. Now it's been 10 months. We could have that's more than enough time, I feel. And 30, 45, 40 days since he got the indictment should be sufficient. He still hasn't gone through it with me.
Okay.
We've been sitting
Well,
there.
I tell you
So
what,
that's basically why I'm bringing up my loss of confidence in him and why I submitted the dismissal
Mr. Hardy.
in case I do lose in trial.
All right, Mr. Hardy, will you go over the indictment with?
She agreed for the case to be dismissed up through a TIC and then to continue on probation. I don't believe there's anything else that you have.
That's it, Your Honor.
Well, on the motions to revoke, we're proceeding on those, correct?
We have agreed to plea on 17 and 19 on these two different motions
All right.
to continue on 2 years, extend for 3 years.
All right, court is calling 2021 CR 4964 2018 CR 11550 State versus, State versus Michael H. Cox II. That party is announced for the record. State,
Andrew Harris Edelman.
defense.
Austin Nagy for Mr. Cox.
And are you Mr. Cox?
Yes, ma'am.
Are you the same Michael H. Cox II who was placed on deferred adjudication in 2021 CR 4964 for the offense of theft, 30,000 to $150,000 on December 6, 2021 for a period of 4 years? And the same Michael H. Cox II who was placed on deferred adjudication in 2018 CR 11550 for the offense of theft, $2,500 to $30,000 on January 14, 2020 for a period of 3 years. Is that you?
Yes.
State, are you proceeding on the same allegation in each motion?
Yes and no, Your Honor. The substance is the same for each, but they have different numbers.
Right.
So in 2021 CR 4964, on or about the 6th day of February 2024 in Bexar County, Texas, the defendant, Michael H. Cox II, did then and there fail to register for or attend a theft program level 2 with the approved agency in violation of condition number 17.
How do you plead to that? True or not true?
State waives the remaining violation allegations, Your Honor.
Any objection?
No, Your Honor.
In 2018 CR 11550, on or about the 6th day of February 2024 in Bexar County, Texas, the defendant, Michael H. Cox II, did then and there fail to register for or attend a theft program level 2 with the approved agency in violation of condition number 19.
How do you plead to that? True or not true?
State waives the remaining violation allegations, Your Honor.
Without any objection?
Yes, Your Honor. No objection.
All right. Did you understand by pleading true to violation of condition number 17 and cause number ending in 64, court could find you guilty, grant the motion, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 17?
Yes, ma'am.
Court will find violation of condition number 17 true. And in cause number 2018 CR 11550, did you understand by pleading true to violation of condition number 19? Court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition 19?
Yes.
Court will find violation of condition number 19 true. And it is the court's understanding that the case that he paid restitution on, that was just some case that had been floating
It
out
was
there.
at large, Your Honor.
Okay.
Yeah.
All right. Is there a proposed agreement?
Yes, Your Honor. In each case to extend probation for 24 months with all conditions in effect.
All right. Probation, and the cause number ended in 11550. Is there a restitution amount that's currently due?
Judge. Yes, there is a balance, there is an amount due, he is currently making payments on that.
All right. The court will deny the motion in that cause number. Alter and amend conditions to extend for 2 years. There's an issue with regards. How long are you asking for an extension?
Judge, we're asking for 24 months on each case. And, we do realize that these cases already expired.
Mhm. With regards to this case, he can be terminated unsat, and the restitution amount can be transferred to the other case.
I don't have opposition to that. The state does.
That's what the court mandates.
All right. Any objection from the state?
No, Your Honor.
All right, what is the amount that's due in cause number 2018 CR 11550?
$7,836.
All right, defense, do you agree that that's the amount due?
That is the amount that I have seen, Your Honor. I do agree that that would be the amount.
And is the complainant Beverly Ahnee, Ahnee?
Yes, Your Honor.
One second, Judge. That is correct, Beverly on.
All right. So any objection from either side to the court terminating him unsatisfactorily in that cause number and transferring the restitution amount to this cause number?
No, Your Honor. No objection from the defense.
Not from the state, Your Honor.
All right. Then the court is going to terminate him unsat in that cause number. And in cause number 2021 CR 4964, the court is going to deny the motion to alter and amend conditions to extend for 2 years. And there's to be restitution to Beverly Ahnee in the amount of $7,836. And probation, when do you want him to sign up for this class?
Is that court start
Yes.
by the end of January?
All right, you're to enroll in the theft course by January 30th, 2025. Do you understand?
I believe I have the certificate. I just.
All right, is there anything else from either side?
Yes, Your Honor. If I may.
Yes.
Here's what makes this case so interesting. Technically, Christopher admitted violating probation, but the judge also recognized that the failure wasn't simply about refusing treatment. It was largely the result of another sentence disrupting the program. That's why, instead of imposing the maximum 6 years allowed by law, the court accepted a negotiated 2-year concurrent sentence and even recommended a therapeutic community program for rehabilitation. It raises an important question. When someone genuinely wants treatment but circumstances get in the way, should the justice system prioritize punishment or another opportunity for recovery? Let us know what you think in the comments.